Thank you everyone for joining us on the New Hampshire Association of Realtors continuing webinar series on best practices throughout the COVID-19 situation. Today I'm joined with Matt Johnson. Matt, would you please care to introduce yourself?
Hi, good afternoon, everybody. We are here. I am counsel to New Hampshire Association of Realtors, and we've been doing a series of videos on COVID-19 related topics. So that's what we're talking about today.
So the big thing for today's conversation as we film this, July 1 is coming up, and July 1 is an important date because Governor Sununu just issued Executive Order number 51, which will open back evictions, which had previously been closed under Executive Orders number 4 and 24. So Matt, can you just remind everybody what happened with those old executive orders and what is Executive Order 51 really doing?
Sure. So we were in unprecedented times with the COVID-19, and this was an example of that. So Executive Order 4 was the first one that said you could not do or commence evictions, or actually foreclosures as well, but evictions for residential or non-residential property for a period of time while the state was in a state of emergency. The order did make very clear that you were supposed to continue to make rent payments and mortgage payments, and that order did not suspend that obligation, but landlords were precluded from accessing the court system to evict tenants during that period of time. That order was then extended one more time, and the most recent order, the court, Governor Sununu indicated that that's going to expire on July 1st. There is one caveat to that order, though, that people should be mindful of, which is if the reason you're evicting the tenant is for non-payment of rent, and that non-payment of rent period happened between March 27th, I think actually March 17th, and June 11th of 2020, you have to give the tenant 30 days notice instead of the normal 7 days. Typically in the landlord-tenant statute, if it's non-payment of rent, you only have to give them 7 days notice and a chance to cure. But under the order, you have to give 30 days notice.
All right, so Matt, walk me through what you just said there. For apartments, is this the only rule and regulation? Because I thought that there was also some rules from the federal government through the CARES Act, which also apply, in which takes priority.
Great question, Chris. And so the CARES Act also overlaid on top of all of the state rules, a federal rule, and there's a federal moratorium on evictions through right now, July 27th. It's unclear whether that date will be extended any further. So that's beyond. So there's a subset of landlords who, even though the state now says you can commence evictions, the federal government says you cannot. And what those groups are, there's a whole category of groups of federally backed properties. But if you have a federally backed mortgage on a 1 to 4 unit property, the July 27 moratorium applies to you. If you have a federally backed multifamily mortgage, which is 5 or plus more units, that moratorium applies to you. So landlords in particular should consult with their counsel before beginning eviction proceedings. Often landlords will do this themselves, or their property managers will do it themselves to start it. You should make sure and check that your property does not fall within the extended federal moratorium, because as a matter of federalism, the federal law will trump the state law, and you will be required to comply with the federal law.
So that's all for the residential bucket. Anything, as you mentioned, 1 to 4 family, or 5 units and up, those two executive orders and the CARE Act apply. As far as commercial property owners, I think you mentioned as of July 1, they will be back to somewhat normal as far as eviction process?
Yes. The only change there is if it's a non-payment of rent eviction, and that non-payment period is within the period I mentioned before, you have to give more notice than you normally would. But on the commercial side, you are basically back to the standard rules and the standard process come July 1.
So as a practical matter, Matt, we're going into these times where the courts presumably might have a big backup. What do you recommend to your landlord clients or your tenant clients who have back rents and are going down this path? Are the courts going to be open? What should we do to avoid the court system? What are your feelings there?
So my feeling on that are the court system, it's really going to be an open question what happens. The courts are struggling to figure out what to do with the backlog. I think from a landlord perspective and a tenant perspective, any arrangement or modification or adjustment that you can make collaboratively through negotiation outside of the court system is probably economically more efficient for both parties because it's unclear how fast the courts will move. And I think both from the landlord and the tenant side, there is a vast amount of potential relief available both at the state and federal level, both from the CARES Act, but also, for example, the Main Street Fund and various other stabilization funds New Hampshire state government has put out there. So I think if you're a landlord, it's perfectly reasonable to ask the tenant to say, hey, what have you done to explore resources or assistance that you might have? For example, certain SBA loans right now, the federal government is paying those monthly payments. So again, there is a giant amount of federal and state money washing through the system right now. And so the tenants and landlords should really take a look and try to take advantage of those resources as part of an overall package to try to stay in the property and survive this challenge.
So, of course, I don't need to remind you as counsel about getting everything in writing. But one of the things that came across my mind is, how do you classify these things? Is it rent forgiveness? Is it rent deferment? Is it rent abatement? If you and your tenant are reaching some sort of an agreement on a payment plan, how you classify that verbiage could have a dramatic impact on the payment when the eviction ban is lifted. Is that correct?
Yes, you are 100% correct. You should, both landlord and tenant should consult with counsel about how to frame this up, and most definitely get it in writing because you really do want a written track record of what you would agree to. And it depends on what the agreement is. You're right. If it's an abatement, it may mean that that's not, you may agree that a certain amount of rent is not owed, but you might have a rent deferral, which just says, look, the rent's not owed presently, but it's going to be owed later on, or we're going to adjust it in the out years where hopefully the financial condition of everybody is different. So again, the devil's going to be in the details in terms of what is negotiated, but I would encourage landlords, especially in this time, and tenants to try to work it out. The landlords have an incentive to keep someone in the property, even if they are not maybe receiving 100% market rent at the time. The transaction costs associated with finding another tenant in this economic climate could be severe. And tenant filing for bankruptcy is no panacea for the landlords either, because the bankruptcy code is frankly pretty favorable to commercial tenants if they file for bankruptcy. So all of those are things landlords should keep in mind, and they should look at the greater overall strategy. And I would encourage people to take a longer term focus on what's going to be the most advantageous position, 6 months from now, a year from now, and not be too quick to seek to evict tenants, because door number 2 there is you then have an empty commercial space that you have to rent. And we all know that doesn't happen overnight.
So for all property classes, for apartment owners and for commercial property owners, banks have been great to work with. I think that everyone agrees our community banks are working well with us. But one of the things that goes through my mind as we both work through these deferments of rent or abatements of rent, and then the subsequent collection after these evictions are lifted, you might unwittingly create a situation where you're in jeopardy of a debt service coverage ratio clause, whereby you have to keep your income at a certain level. And if the income drops below a certain level, you're in technical default on that mortgage. Is that correct?
That can be correct, yes. And so that's a great point. And sometimes that's a point that tenants often overlook in this process, which is the landlords often have a mortgage on the property, so that the rental income they're receiving is not just going in the pocket of the landlord, but it's in many ways a large chunk of it is a pass through to handle the debt service on the mortgage. And so the landlord most definitely, if they're considering some form of abatement, deferral, forbearance, anything with their commercial tenants, they need to be in contact with their loan officer, and they need to be talking with their bank. Because I agree with you, Chris, the banks have been very understanding and recognize a unique set of circumstances, but they don't recognize them if you don't tell them about it. And so it is much better to be on the forefront, have that discussion, make sure that you have a commitment from the bank that they understand that, and they often, they can waive those covenants. They can make it clear that that's not going to apply. They may even have a forbearance agreement with you that parallels the forbearance agreement you have with the tenant, so that your monthly mortgage payment starts back up once the tenant starts making payments. So in other words, there's lots of creativity out in the marketplace, and there's lots of opportunities to try to protect all sides to the transaction.
Well, great. Well, thank you, Matt, for joining us, and thank you to all our viewers who are with us today. I would encourage anyone with questions about COVID-19 or any other situation that relates to the real estate industry, please reach out to your local board president or reach out to the New Hampshire Association's Concord office, and we'll be happy to get some Q&A, some timely Q&A to deliver back to you, the members. So thank you all for joining, and thank you, Matt, for being with us.
You're welcome. Thanks for having me.